Have you ever promised something in the heat of the moment and immediately thought, wait, did I just make a legal commitment? Imagine telling a friend, I'll sell you my laptop for $300 on the spot, only to wake up the next day realizing it could have been $500. Now, picture if this happens in a business context, one wrong word, and it could lead to serious legal trouble. The law doesn't care about your regrets, it cares about offers, acceptances, and consideration. These three pillars form the foundation of every contract, from the simplest coffee purchase to multi-million-dollar business deals. And if you're an ACCA student, mastering them isn't optional, it's your ticket to scoring high marks on exam questions that look simple but are packed with traps. Let's start with offer. Think of it as the spark that ignites a contract. But not everything that looks like an offer is one. Picture walking into a bakery and seeing a cake labeled Chocolate Delight $10. You might think, that's an offer, I'll take it. But in law, this is just an invitation to treat. It invites you to make an offer to buy, but it isn't binding. The real offer happens when you say to the cashier, I want to buy this cake for $10. The distinction seems small, but ACCA examiners love to trick students with it. For instance, in Carlill v. Carbolic Smoke Ball Co, 1893, the court treated the advertisement as a real offer because the company had promised a clear reward and showed intention to be bound. Exam tip: always ask yourself, is there a clear intention to be legally bound? If not, it's probably just an invitation to treat. Once we have an offer, the next step is acceptance, the magic moment that turns a proposal into a contract. Acceptance must be absolute, unconditional, and communicated. You cannot say, I'll buy your car, if you replace the tires. That's called a counter-offer, and here's the exam twist, it kills the original offer. Classic example? Hyde v. Wrench, 1840. Where the buyer offered £950 for a farm, the seller rejected it, and later the buyer tried to accept the original £1,000 offer. The court ruled, no deal, your counter-offer killed it. Real-life scenario: Sarah, a freelance designer, offers a logo design for $500. The client replies, can we do it for $400? That's a counteroffer. Even if they later say $500, Sarah isn't bound unless she reoffers. Acceptance also has timing and method rules. Generally, it must be communicated directly, unless the law provides otherwise. Silence usually doesn't count as acceptance, so if a client doesn't reply, you can't assume they agreed. But here's the twist, the postal rule. If acceptance is posted by mail, it's effective the moment it's sent, not when it's received. This tiny detail has appeared in countless ACCA exam scenarios, a perfect example of a mark-winning insight that many students overlook. Next, let's talk about consideration, the element that gives a contract its teeth. Consideration is basically something in return. You can pay with money, provide a service, or even give up a legal right. The key is that it must be bargained for and must be real. For example, if you promise to pay $300 for a laptop, your $300 is consideration. But if someone promises to give you a laptop for free, that's a gift, no consideration, no binding contract. Exam trick: beware of past consideration. If someone has already done something before the promise, it usually cannot count as valid consideration. A classic case here is Re Carlill, 1951. A family promised to pay for home improvements after they were already done. Court said, no consideration, promise unenforceable. Knowing this can save you from giving a wrong answer in exams. Let's make all of this more tangible with a real-world ACCA-style scenario. Imagine a startup called Bright Tech. They approach a freelance dev, boom, contract formed. Eloper, offering $1,000 to create a website. The developer immediately replies, I accept. Boom, contract formed. But what if the developer had said, I accept, but only if you also provide content? That's a counteroffer, not acceptance. If Bright Tech later tries to enforce the original offer, the court would side with the developer, the original offer died. This is exactly the kind of scenario ACCA examiners love: simple facts, tricky legal implications. Now here's an exam-winning strategy. Whenever you see a scenario question, break it into 3 steps. Offer right pointing arrow, acceptance right pointing arrow, consideration. Ask yourself, was there a clear offer? Was acceptance absolute and communicated? Is there consideration? Then, look for exam traps, counteroffers, past consideration, silence, advertisements, or timing issues. Highlight them in your answer. It shows the examiner you understand the nuance, not just the textbook definition. And here's a small tip that often differentiates top scorers from average students: use case names wisely. Sprinkle in Carlill v. Carbolic Smoke Ball Co., Hyde v. Wrench, and re McCardle where relevant. It not only demonstrates knowledge but also makes your answer memorable and examiner-friendly. Finally, let's sum up everything with a simple story framework that will stick in your brain. Imagine a three-legged stool. Each leg is offer, acceptance, and consideration. Take away any one leg, and the stool collapses, just like a contract. Every time you study contract law, visualize this stool. Think of Sarah the designer, Bright Tech, and the bakery scenario. This combination of story, real-world example, and exam trap will make these concepts unforgettable. So, to all ACCA students watching, if you want to pass with flying colors, don't just memorize definitions. Visualize scenarios, anticipate traps, and apply cases. That's how you move from understanding to exam mastery. Hit that like button, share this with a friend who's struggling with contract law, and subscribe to Education Bench, because the next episode will unlock intention. To create legal relations, another exam favorite that can make or break your score. Remember, law is not about memorizing, it's about thinking, spotting traps, and applying logic. Make it stick, and you'll not just pass, you'll ace it.